Let's make sure we record. I'm going to ask Derek just to give a quick reminder as to what Men of Value is all about, and we'll then sort of just jump into it. Welcome to Value Edians. Welcome to the ambassadors. Welcome to guests who are coming on for the first time. Derek, this Men of Value thing, let's just explain it before we ask the attorney to take the stand and have a chat to him a little bit. So over to you, my man.
Morning, everybody. All protocol observed. I've had quite a few government sessions as of late, so I have to be sure that everyone is honored. But to show how different we are as Men of Value, everybody here is recognized in our protocols. So thank you so much for making time on a Saturday morning. I know it's not easy, and I know that the days are getting shorter and shorter. Isn't it strange that the more tech around us, the less free time you have? It's really ironic. But welcome to a Men of Value session. Guys, Men of Value really is I don't want to call it quite a program. It's probably more of an intervention come lifestyle that we're doing. We're really trying to get men to step up, and we'll touch more around that, but that's what really Men of Value is about. We try to have conversations that enlighten, conversations that build us. Very key is that we build one another. And also knowing that, in life, you learn from your mistakes, probably more than you do from the things you do right. So we as Men of Value value that aspect as well, that we're forever learning. And it's a lifelong learning cycle that we're on. Guys, my name is Derek Mzoneli. I'm part of Men of Value. Being part of Men of Value doesn't mean that I necessarily am a Man of Value. It's something that we espouse to. So I'm trying in every day to be a better me. And I'd like to think those who've joined us here are also trying to be better men themselves. We call ourselves Men of Value because I think we found there's a huge need for men in particular, people of the male gender, to step up. And we've had quite a few sessions around what are the challenges of stepping up and what are some of the ways we can do that. And we'll touch on that even some more today. But of course, we welcome the ladies as well. Thank you so much for joining us. And we really value the input across the gender spectrum, I should say, in the modern world. So please, everybody get involved. These sessions are not really about sitting back and listening. Yes, listening is a very important art. It's a technique. However, it's also about feeling free to speak up, to share your thoughts. So please, in these sessions, we have a couple of rules. One of them is no judging. So, if someone does say something and it's not quite your cup of tea, we still push on. And I think it's in addressing these challenges. If someone would raise their hand and say, "Oh, geez, I hit a woman, 2 weeks ago, or whatever," and we deal with it, we handle it because we're dealing with real life issues. Furthermore, we really would ask that you don't sit on your thoughts. This is a safe, interactive environment. And I think any literature you read speaks about the importance of speaking up, of being open to your feelings. And then the general protocols, of course, guys, the general rules around this these virtual meetings, which we all have perfected, I'm sure. If we keep our mics off when we're not speaking, and you can always post your questions on our chat group. And one of the things we encourage is putting on your camera, especially when you're speaking, so we can see you and we can interact a bit more. And in fact, we even don't mind seeing men cry. In fact, it's one of our objectives here is to say, let us take that big step. Because I think, when you're a man and you haven't cried in 5-6 years, you probably need to wonder, why is that? And that's a discussion for another day, but be asking yourself, as a Man of Value, how come I never cry? How come nothing allows a tear to come out of my eye? Guys, in terms of what we try to do is we really like to be action orientated. So there's a couple of things that Vic will chat around a bit later on in terms of some of the interventions we're trying to do, starting with where you are, really within your circle. So we chat a bit around that, but being action oriented is one of our big action, or one of our big steps that we take. You also need to do your own personal balance sheets and assess yourself. And I think that's why I was saying I'm not a perfect man by any means, but we'll definitely try to do that. And then, of course, in the rehabilitation space, I mean, we have even gone as far as trying to intervene even with people who've actually served time. And, we really want to get even to that level of rehabilitation where we're saying men are good and all men can be good. We're intervening at an early age, hopefully, but with young people, and we can intervene even with elderly people to try and create better men around us so we can have a better environment. So guys, I hope you got a gist of what Men of Value is about. Yes, our focus is on men, but definitely the views and assistance we need from women in developing ourselves is really huge. So please, everybody, participate, get involved, and let's get going. Yeah, guys, without any further ado, I think I will hand over to Vic to do an intro. We are sitting with Robin Tato Malinga today, who Vic is going to introduce us to us now. Thanks.
Absolutely. Thank you, Derek. And I just thought before we jump on there, let's just give you a sense of some of the pledges that we have made. And we're going to add to these pledges as we proceed. These are as what has come up as a result of the last sessions that we've had. So one of the things that Derek mentioned is that we are conversationalists in action. This is a pledge that we make. In other words, we talk. We've got to talk. And I think our guest today is going to allude to the importance of that as well and the power of that. We got to speak as men. We will never use violence inappropriately. We use the word inappropriately because, as men, one of our functions is to protect, and where protection is necessary within the bounds of the law, Mr. Malinga, we will certainly evoke the need to do that by any means necessary. We say, I love you. Men, we say, I love you. These are the pledges that I want you to review in your mind when last you used the words, I love you, to your children, to your spouse, to your loved ones. We say we love you. We hug. And the hug we're referring to here is not that shoulder to shoulder bear hug as guys do. I mean an embrace. And I don't necessarily mean with each other, but we need to start inculcating that as part of our physicality, where we embrace, we hold each other, right? And then last but not least, we mentor. Somewhere, someone has to be looking up to you and saying, this person influenced my life, right? And I'm trying to think about that for those of us who have children, over and above our children. Obviously, our children is a given, and that should be the case. But over and above that, who is saying that you are influencing their life? So with that, it gives me great pleasure to introduce our guest today, Mr. Robin Malinga, otherwise known as Tato. And Tato and I met several times during the time we were still wearing a mask. So I was actually saying to Tato right now, it's very nice to see the other half of him. I know if I was to pick him out in a lineup, I'd ask them to please put masks on everybody, and I'd just look at the eyes and I'd get it. But now we've got the full face, so it works. So our attorney Tato, Robin Malinga Tato is an attorney. Somebody who needs, please mute.
I think Mashudu, your mic is on.
There we go. Yeah. And I'll mute Mashudu. So Robin Malinga, otherwise, as I said, known as Tato, is an attorney. He is a family law attorney, and he's a director at his company, Robin Malinga Incorporated Attorneys. He's a family man, that much I know, knowledgeable and wise. and experienced in this space that he's going to be having a conversation with. I said to him that we should have a conversation around the challenges of men and the legal system. He's exposed and sees quite a bit. And one of the things that Tatu is able to see is what I call both sides, right, Tatu? So I think there's a sense with a lot of these things that, you know, things are one-sided, but he's able to see both sides. Importantly, the role of men in society, from what he's seen, you know, what is the role of men? And some of it is what I would call instinctual roles that we should be doing as well, but others is legalized roles. You know, these are things you have to do. And if you don't, you're in violation. And yeah, and just to get a sense of from him what is going on in the other side of the fence. Tatu, we've just, you know, I know this is not part of this is criminal no more than anything else, but it talks to, and I was Derek, just it talks to this thing of these men who were released from the Krugersdorp, you know, issue. I put on my other hat, you know, very briefly, just to say, imagine those young men, because some of them were young, Derek, they were 16, 17, 18, right, who have been incarcerated for a crime they did not commit because of police bungle. Yes, they are foreigners and they are underground and they're zama-zamas, but they're children and they've been incarcerated for something that they didn't do. Just let's bear that in mind as well. Hey, Browska, welcome, welcome, welcome. So with that, Malinga, can we bring you in and allow you to kick off and give us a sense of what's happening as a family lawyer and what's happening in the legal system in context with men and women in general. Thank you for joining us.
Thank you so much for having me. I'm really honored, gentlemen and ladies. Thank you for having me. I think I've taken a very subtle approach to what I will be discussing today, but I know for a fact that it affects a lot of men in general, more especially when pertaining to children. I think I've decided to take the topics along the lines of the rights of unmarried fathers. What are the rights of unmarried fathers? Because you would see generally in society what happens is, or the perception is that the mother is the one with all the rights, and if anything were to happen, the children must go with the mother. But where does it leave the unmarried fathers? We'll branch off into the aspect of maintenance of children, the responsibilities associated with unmarried fathers and the maintenance of their children. What are the legal implications of that? And then we'll look into the more unpopular topic that very little legal practitioners would like to discuss, and that is the weaponizing of children as against married and unmarried fathers. So I think if we can dwell around those three topics that I will be dealing with briefly, without going into the jargon and to the alpha matrix of what the law is, because the disclaimer behind that is also that with legal opinion, it's always good to get counsel and be individually assessed, because each and every case is on its own merits. My case will not be the same as yours, Mr. Rankin. So it's always good for us to discuss things in such a manner that they are so broad that we generally just have an overview of what is happening in that legal space. And as and when we encounter these things, we seek private legal counsel so that the dynamics are brought down to specifically our own facts. So that's basically what I'll be discussing today. I think what I can do is let me start by discussing the rights of unmarried fathers in general, right? So legally, what has happened recently is that through the introduction of the roles of the family advocate. So what we have is, we have, for example, a father here who is unmarried, and he has a child, and when that child is born, obviously the child resides with the mother. So the father and mother are residing in two different homes. The child is being brought up in the maternal home. Now, the father is basically only granted the responsibilities of maintenance and access to the child. Now, normally when the relationship disintegrates between the father and the mother, and there's no longer a love relationship between the mother and the father, you will find that the issue of the children is now brought up. You'll find that the father is now no longer sufficiently maintaining the child. You'll find that the mother no longer provides the adequate access to the child, for the father to the child, or you will find that there is an element of abuse that comes in from the father or from the mother towards the child. So let's discuss the issue of the rights of an unmarried father and what his rights are pertaining to the child, even though he's not married. So it does come about that there are cultural aspects that come into play, which I have seen quite a few, where if, for example, in my culture, umntwana uyahlawulwa, you pay, or for example, I'm not sure what you would call it in English, but I'm sure you will understand what I'm alluding to, where the cultural expectation would be, if you are unmarried and you're not intending to marry the mother, then you would be obviously expected to pay a certain kind of damages in relation to that child. Some cultures even permit for you to marry the child. That's what they would term it. Ngishada umntwana, so that umntwana will have my surname, and then I would then be able to continue my bloodline through this child. But what normally now, what I've seen recently is the role of the family advocate has come in specifically to mediate these kinds of issues. I'm not sure if I'm going too fast, but like, I'm just giving a broad overview of the problems and the remedies in place for such problems. And that's basically how the legal system works.
Yeah. Thanks, Robert. No, I think you're going fine. I think what we'll do, there'll be the question that gets on the chat group. We'll address those, but we usually find that feel free, just speak whatever you want to say. We'll probably easier if we come in at the end. Guys will be jotting down their questions, and then we'll go around and ask questions. So we're definitely understanding you. So just continue on.
Excellent. All right, so everything's fine so far. I think we should be in the clear. All right, so basically what I'm saying is that how the legal system works is it identifies problems, puts measures into place, and expects everyone to conform, comply with the rules. These are the rules that are in place for such problems, and these are the platforms where such problems can be discussed, right? So when pertaining to the rights of unmarried fathers, there are different platforms that are available for different kinds of problems. Right. So the first would be the maintenance court. Now, the maintenance court is primarily there to deal with only issues of maintenance. The maintenance, and not only financial, but the social well-being of a child is a really big factor in that court. And the affordability of the parent is an extremely big factor in that court, because that determines what is adequate for the child. Now, then you will get the children's court, which deals with various aspects, and these aspects have been termed by the family advocate as follows. So you would have care. Care is where it is decided who resides with the child, who is the primary caregiver of the child. Then you will have guardianship. Now, guardianship speaks primarily to your ability to be able to administer the affairs of the child, administer the property of the child, administer the social requirements of the child, because the children are not the same. Some children are epileptic, some children have Down syndrome, some children, so it makes, it just puts a whole room around that aspect of the child. So care, guardianship, and your parental rights and responsibilities. So my parental rights and responsibilities is not only the aspect of maintenance and the aspect of access to the child, who gets to see the child when and how. So all of these are dealt with in two different courts. So your maintenance court and your children's court will deal with those aspects separately. Then we will have an umbrella above the two, which would be the family advocate, which deals with mediations and recommendations. Now, the family advocate's role is basically to act as a mediator between parents with disputes regarding children. Now, when the family advocate's role is basically to be a mediator, and make recommendations for either the maintenance court or the children's court to follow that recommendation. So what the family advocate will generally do, they will send out, for example, a social worker to come and see where you're living. Is it conducive for the child? Is this where you will be raising the child from? Is this a proper environment for the child to be raised in? How are you intending on moving the child from here to get access to the father, for example? Are you under any narcotics as a parent, for example? So those are the things that the family advocate would look into, so that the child's interests are looked in, are properly taken care of or supported for. In terms of the Constitution, no matter what issue is there between an unmarried father and unmarried mother, it is always the interests of the child that are of paramount importance. So in anything relating to a child, in all honesty, the interests of the parents are the least of what the court cares about. The court is more concerned about the interests of the child in any disputes involving a child. Those are that's the standpoint that the court will take. Generally, I see a question here. Generally, when a child is, for example, being taken care of, the parental rights and responsibilities of a child don't cease. So the court will generally say, until a child is above the age of 18 or self-supporting, then the family advocate ceases to be a mediator with relation to that child. So, for example, you'll find that a child is 22 years of age but has Down syndrome, or that child is has cerebral palsy. So the affairs of that child still require either of both the parents to administer them. So you'll find that there's disputes because the parents are not in good terms. So what would then happen is that the family advocate can then be involved, say that we are administering the affairs of this child, but we need a mediator because the child is unable to fend for themselves. So because we both have the rights to administer this child's affairs, why don't we get a mediator to assist with making decisions and recommendations relating to that child? I think with regards to the roles of an unmarried father. That's about the umbrellas that are there and the measures that are in place. What has recently come about that before, the unmarried father didn't have as much rights as the mother of a child born out of wedlock. So recently, and through various cases, I think the Constitutional Court has various cases. I'll share some of those cases with you, just a brief summary of them, of the issues that were faced there, and what the court has decided, and how the law has changed now, because the law is ever evolving. And so recently what has happened is the rights of an unmarried father have been what we call have been termed secured, meaning the unmarried father now has equal parental responsibilities. So what this act does, it's the Children's Act, and what it does is it gives equal parental rights and responsibilities specifically to the parents. So it says the father will have equal rights and responsibilities. However, specifically, he will have access to the child in such a manner. He will see the child in such a manner. And all of those are case specific. So it also puts sanctions to the mothers. For example, if an unmarried mother is now prohibiting access to a child, to the father, towards the child, and he prohibits it upon conviction, because that is now against the law, according to the Act. A person who prohibits access to a parent who has parental rights and responsibilities, upon conviction, can now be liable to a fine or conviction or imprisonment for a period of not more than 1 year. So the aim of the law when coming to the parental rights and responsibilities is to strike a balance. You give the right, you give the responsibility, and you strike a balance so that the parties involved in that situation are able to remain within the confines of the law. So because the mother is not happy with you doesn't mean that you're not allowed to see the children. But however, we are seeing a lot of that these days. And it's very important for I think men to know their rights when coming to access of children, and what their rights are regarding the duration of that access, what their rights are regarding the overall parenting of the child. I think it's very important that as men we look into that. I think this is a great platform for such a conversation. It brings about the self-awareness and your knowledge of what you have as a right, so that you know how to fight some of these battles that come your way, especially if you're an unmarried father. Now, I'm not sure if I can close that topic off, because I want to jump on to maintenance. It's one of the topics that really hit home, because a lot of men, you'll find in the maintenance court, it's mostly women making these applications against men for either the lack of maintenance or the inadequate maintenance of the children. However, this is also used as a weapon against men who should be maintaining but are not doing it adequately enough, or those that are doing it adequately enough and don't have the means to do more than what they are doing. So I think I'll jump onto that. Maybe can I just pause for a second and find out if there's any questions regarding the rights of an unmarried father, anything else that wants to be known regarding the rights of an unmarried father, so that once I move from that, because maintenance is a totally different aspect, and then we'll be discussing that on a broader scale. Are there any questions? Can I open the floor for that?
Thanks, Robin. Thanks, Robin. There definitely would be questions. It's very interesting that the law is evolving and ever changing.
Mhm.
What would you attribute men getting, I'm going to call it, having more say in these situation. What do you, in this platform, we're saying men of value is a big challenge, and men stereotypically have such a negative, are viewed so negatively. What might you say has happened that's caused that shift, where men actually get to have more rights?
Well, thank you for that. I think it has become more evident in more and more of these cases, because remember, what we use, what we call stereotypes. So stereotypes is basically the precedence that has been set. The precedent that's been set has now turned down the tone, because it's now becoming more evident that more fathers want to be involved in the children's lives. And that right should be granted to them because they are an equal parent, with equal abilities as the mother does. So the involvement of the family advocate has shown the number of single fathers who are manning households, as opposed to the number of single mothers who are manning households, who are single-handedly moving on households. The distinction isn't so different. Hence, the court has now come to a point where they've given equal parental rights and responsibilities to all parents, unless if the parent is not fit to be a parent and have rights and responsibilities, then those are taken away by the court, because that is within the child's best interests. But in all honesty, it just shows the affection and the willingness of parents to want to be part of their children's lives. And that right shouldn't be taken away willy-nilly. So the court has made provision for that. The court has now come, there's different organizations that have been brewing on small scales of the rights of fathers. And it's concerning, because what these organizations are now pinpointing is that there are no repercussions for the mother who's infringing on the father's rights. The repercussions are so minimal that there is no deterrence. There's no deterrence, there's no rehabilitation or teachings to the mothers as to what constitutes a breach of these fathers' rights. So hence the sanction to say, if you are now going to be breaching on the father's rights, we are going to be doing this. So we'll either fine you upon conviction, or we'll put you in jail for a year, so that you can understand how serious this is. So this is where the law has come to now. Generally, what would happen is that a mother would say, you don't see the children because you don't maintain the children. But the father is unemployed. Does that mean we must hinder access? It doesn't make sense. The law doesn't operate that way. So hence the issue of maintenance and access has been separated into two different courts, so that if we're in maintenance, I can't be saying, I'm not supporting this child because I'm not allowed to see the child. Those are mutually exclusive topics that shouldn't be dealt with under the same umbrella. So hence, I think our legal system when dealing with children is actually structured quite progressively. It makes room for improvement. I think we've improved a great lot. Fathers now have their rights, but it's just the educational aspect of it that fathers need to know what their rights are. And in all honesty, we have great fathers there. I mean, out there, it's fathers who don't neglect their children, but it doesn't mean that if the father is not working, he's neglecting his children. It's not how it works. Yes. Absolutely. So these.
All right. Oh, thanks for that, Robin. I think Vic also had a question. I see Palady has one as well. So Vic, if you can jump in with your question. But guys, this is quite a eureka moment. Quite a eureka moment to say that the courts recognize men of value. The courts recognize that men have value, and they've therefore given us rights. Yeah, that's really eureka. It's significant, guys. I mean, it's almost as if Robin has come and said, hey, guys, I got some good news to share. The courts have uplifted you because they believe men are good. we need to step up. Good stuff. Yeah, Vicky, you had a question?
Yeah, no, I
And then
mean,
we'll
just
go for
to support that, Derek. I mean, the older we get, the more experiences we have. And I've seen good friends, good men, really be challenged around their accessibility to children, etc., who really want to be part of children's lives. And are denied that, and that's used predominantly against them. So the question I just wanted to quickly ask, technical one, unmarried father, I presume that includes a father who was married but now is divorced? Or is that purely somebody who's never been married before?
Correct.
So it includes the person who's been married and divorced?
Correct. So now what has happened is with married parents, so children who are born within wedlock and not out of wedlock, the rights of the parents who are married are different from the rights of the parents who are not married. Because for example, automatically if the two parties are married, the children the parties have what we call care and primary residence. But in the rights of in the case of unmarried fathers, there is no automatic care. Care is normally with the mother unless there are extenuating circumstances that allow for care to be automatically with the father. For example, the parties are unmarried, the mother is a drug addict, and the father is not on drugs. And therefore, the environment where the mother is residing is unconducive for the children and not in the best interest of the children. Therefore, care would now shift to the unmarried father, as opposed to in the case of married parents where they're all residing in the same household and therefore automatically the father has automatic care, which is primary residence. So that's the differentiation that is made by the court in order to make it, in order to make the flow of litigation more easier for the court to understand exactly the circumstances. So it's basically a categorization.
Okay. Okay.
Excellent. Excellent. Hi, Paledi. Yeah, Paledi, you had a question? Please go ahead.
Yes, sir. Morning, gentlemen. Thank you very much for the talk. My question is around the speed of the process. I think it actually, the question stems from being so used to having a slow justice system that even Uncle Vic says he's had friends who are challenged around the issue of access. So how long does it typically take for an unmarried or divorced father to get or to be granted access? And are there ways that said father can expedite the process? I'll listen on air.
For sure. And can we take one more question?
Are there any other questions, folks? Nope, I think that's it. I mean,
well, there was one that was on the chat. You might as well ask it. It's probably linked. Up to what age do family courts mediate around children?
Sure. So I think I have dealt with that during my submissions. It was so a child is obviously categorized as a child up until the age of 18. However, in terms of maintenance, and I'll tell you what, I take a very cultural approach to this, and I'm going to answer this in a very cultural manner. A child will forever be a child to a parent. In all honesty, I've seen this happen because we make applications for maintenance for people who are 25 years of age and in university. So in all respects, a child will forever remain a child to a parent. However, what the law says is a child will be deemed to be a child until the age of 18. But that is not where the role of the family advocate ends. Because when a child is 18, they still require the maintenance of the parent, they will be regarded as a child until they are self-supporting. So that hence my answer to say a child will remain a child to a parent. So until the child is self-supporting or reaches the age of 18, they will be regarded as a child. Now, you will find at some point, for example, the example I made, a child has cerebral palsy, they are 25 years of age, and they need care and guardianship from either of the parents. And that is an issue that both parents are having or at loggerheads about. The family advocate will still be able to adjudicate upon such matters. Alternatively, a curator will be appointed, and that curator acts in the speed of what the family advocate would be doing initially. So if it actually does depend on the circumstances of that case, but the family advocate will normally go up to 18 or until the child is self-supporting.
Okay, that's okay. And the process, how long it takes from Paledi?
Oh yes. So thanks, Paledi, for that question. And you can come. Thanks, Paledi, for that question. So basically, how the process works is, if your access is being your right to access is being infringed on, you will approach the children's court where the child resides, or in the area where the child resides, and that children's court will then immediately issue a directive. So what the directive would say to the mother, please, on such a date, come to court for us to inquire as to the access of this child and why you are prohibiting access. Then the mother is then given a chance to come to the court and say, I'm not giving this gentleman access to the child because of 1, 2, 3. And if those issues, for example, they'll say, I'm not giving access to the child because of a drug-related issue, or an abuse-related issue, or either of one of those really serious reasons that make sense to the court, and show the court that it's in the interest of justice why she's not giving access. Then the court will do an inquiry. So this will be immediately when you arrive, you get a directive, you go with the police, you go and serve the directive. The court is basically summoning the other parent to come to the court and explain to the court why this other parent doesn't have access. Then they'll look into the reasons why access has been prohibited. Once the reasons have been looked into, if it requires, they will refer it to the family advocate from the children's court. They'll refer it to the family advocate for the family advocate to make investigations and recommendations so that the magistrate knows what the actual circumstances are between the two parties. Now, what normally happens is that they will do an interim order and say, the father is now permitted to see the child on a weekend basis, on alternative weekends. And depending on each circumstances, so if the baby's 6 months old, I mean, they would rarely allow for sleepovers if the baby's breastfeeding or anything of that nature. But you'll find 5, 6-year-olds, they will permit sleepovers and the likes if the reason of the mother is not adequate to prohibit the access to the father. So what normally I've seen in some of my cases, the mother would come there and say, but he's not maintaining the child. And they tell the mother, but it's mutually exclusive. It doesn't make sense why you would prohibit access on the basis of maintenance. And therefore, we are now making a court order to say you will give this gentleman access to the child every Friday to Sunday from 5 o'clock on a Friday until 5 o'clock on a Sunday. And should you not comply with this court order, then you will now be arrested for contempt of court because you've breached a court order which specifically says you should give the parent access in such a manner. So the duration, I just want to say, there is no specific duration to any case that you can put. So myself and any of the people on this platform now could have the same issue, but depending on the court role and depending on the placement of those cases and the case flow management system in each court determines how long it takes for such matters to be resolved. However, it is an ongoing struggle, and hence I always say that it's always up to the attorneys to make sure that our clients are not in court over things they shouldn't be in court for. So if there's a matter that we can deal with now, it's up to the practitioner to make sure that he reduces the duration and extends the outcome. That's possibly one of the things that should be taught in our ethics, but it's primarily that's what should be done. So with regards to duration, there is no specific duration, but there is a set out process as to what should be done, when and how it should be done.
Thank you. Yeah, thanks, Robin. Phew. Yeah, it's difficult having such emotive and real life matters, such as access to children, and there isn't a very set, clear time frame, as in, well, if you guys don't come to an agreement or within 24 months, the court will decide what happens and that goes. But wow, that's interesting. Any other questions, guys, while we were on the unmarried father's rights topic? I know that Robin was ready to move on to maintenance, which I know he's touched on a bit now, but any other questions? All right, Mr. Malinga, I think you can move on to maintenance in a bit more
All right.
detail.
So what I had prepared with regards to maintenance is basically also just an overview and an awareness of what is actually happening in the maintenance court and how these costs are calculated. And this is also case specific because our income generation will never be the same. The child's requirements will never be the same. And obviously there's an aspect of escalation as well. So maintenance just generally doesn't remain the same. The cost of living has become something inexplicable to man nowadays. But however, when coming to maintenance, these are the things that I think, from my perspective, being a male attorney and father, men of value need to know. The maintenance is a right of every child. Every child has the right to be maintained. Every father, whether married or unmarried, has the responsibility to maintain the child. It's a gift from the stars if it's on a 50-50 basis, because it seldom happens that way. And I will also speak about how maintenance is used as a weapon by either of the parties, whether by prohibiting maintenance or by requiring more maintenance than you should be getting. And that's what we're seeing in a lot of these court proceedings, is that people can either be fishing for more or withholding maintenance that they should be giving. And those are what we call the weaponizing of maintenance processes. And it's sad, in all honesty, because at the end of the day, the child suffers. So the process aligned with maintenance and what has been put in place by the courts is as follows. So they will have an inquiry. So if a maintenance application is lodged against a father, for example, now the father will be given a directive as well. So the mother will go to the court and the mother will apply for maintenance, and she will stipulate what her expenses are. She will stipulate what the children's expenses are and give a total expenditure list of what she's spending with regards to the children. And that list needs to be substantiated by supporting documents that show that these are actual monthly costs. And so it's not fictitious costs, and those will be looked into in that inquiry. So mother will come in and say, I'm paying this much rental, I'm paying this much groceries, this is what I'm using for travel, this is what I'm paying for school fees, I'm in school, so this is what I'm paying for my books, an entire expenditure list. This is what we call a Section 6 inquiry. So this inquiry is the first inquiry that will come before a maintenance officer. So mother comes in, she wants to apply for maintenance. The maintenance officer will then give a directive to the police. Go and serve this gentleman with a subpoena. He must come to court due to an allegation as to his failure to pay maintenance. And then the court will issue a subpoena and say, Mr. So-and-so, on such a day, please come to court. We want to look into your finances. And on the day when you do come to court, please bring the following documents. So we'll need 3 months bank statements, your ID, your proof of address, a list of expenditures that you're incurring with either in relation to yourself or the children. And the court will now sit down with those two submissions on the initial maintenance day. Now, the first maintenance day is normally in front of the maintenance officer. As to whether what affordability is in relation to, as opposed to what has been requested by the mother. So if, for example, the mother has requested a maintenance of 10,000 rand, they will look into your affordability and her necessity for what she has requested, because not everything is a need for the child. Remember, the father is to provide for the needs of the child. It's not necessarily the wants of a child, but it's also within the needs and the affordability of the father. So that affordability, it takes about probably 2 appearances just to make sure that there's proper bundle submissions, and you can look into the veracity of whether these expenses are actually incurred and not thumbs-up. Then it will move on to a Section 10 inquiry. Now, that Section 10 inquiry is before a magistrate, who will then order what is reasonable as in line with your affordability, income, and what is left over. And remember, however, the child's interests are of paramount importance. So you cannot say that you are paying for DSTV while you are contributing nothing to the child's maintenance. It doesn't hold water. You cannot say you are spending 5,000 rands on medical aid, but the child has no adequate contribution on the groceries. The child has no adequate contribution to cosmetics, your nappies and milk, for example. But you're paying a medical aid of 5,000 rands, for example. So hence, it's very important to always put forward what is important as opposed to the child's maintenance. So some of these requirements that are put and the requests that are put by the applicants who are making maintenance applications normally do fall away if they are shown to be either exorbitant or luxurious. Especially in the case of unmarried fathers. In the case of married fathers, you'll find that they will try and keep the father to subscribe the children to a lifestyle that they are acquainted with. That's what the court would normally do. But with regards to maintenance, the overall submission that I want to make is that the court looks at your affordability, they look at your expenses in conjunction with that, and they make a ruling with regard to what is reasonable as maintenance regarding the child or children. The court will make orders regarding the 2 aspects. So they'll make a cash component order that will say on a monthly basis, you need to give such and such a person this amount of money for them to be able to do the following. Or they will make a non-cash component order, which would say you buy the children winter clothes and summer clothes in these amounts, and this is what's reasonable based on your income. However, legally, I want to say that it's not always mandatory for you in a maintenance application to make your payments in cash. I don't know any law that forces any man to make any payment towards maintenance in the form of cash. And I think this is one of the strategies I started adopting in my submissions to magistrates to say, this woman is now requesting this much from my client. However, we are not certain whether this money is actually going towards the payment of these things. Could it be that she is weaponizing and using the maintenance process as a weapon against my client because she knows my client's affordability? So what submission would mean, what the submissions that I would normally make would be, could we have this account for the school? Let's pay the school direct. Could we have the account for the transport driver? Let's pay the transport driver directly. Could we have the account for such and such a thing? Can my client fetch the children, go and buy groceries with the children so the children actually buy what they feel they need because they are at an age appropriate enough to make these decisions? And the Children Act makes provision for age appropriateness. That's sitting on section 6 and 10. Section 10 of the Children's Act looks at the child's age appropriateness, their age awareness, for them to be able to make certain decisions. And these decisions do not need the intervention of the other parent when the one parent is there. So it's very important to note that the court does investigate thoroughly what your income is. So they could come up with an investigation. So the maintenance officer's duty is basically to investigate thoroughly what your income capacity is. So they can go into your bank accounts and see where you hold accounts. They could go into your pension and provident funds in order to see what you have as a potential for future maintenance. Now, I'm going to go into the breach of maintenance to show you the repercussions of what could happen, if you are willingly or effectively neglecting to pay maintenance after it has been ordered that this is what is reasonable for you to pay as maintenance, and the repercussions of what could be due to the failure of the payment of that maintenance. So after the court has issued a maintenance order and the father, for example, fails to upkeep the order as recommended or as ordered by the court, and they fail to comply with that order and make the maintenance payments as required by the order, the mother, or the complainant is what we term the mother in that term, will go back to the maintenance court and file for an enforcement. Now, that enforcement will come with sanctions upon the failure of that enforcement. So the court will say, you were ordered to pay 5,000 rands a month in relation to 2 children at 2,500 rands each. You are now in default of 6 months. And you are therefore ordered to pay these areas in such a manner. Now, should you fail to pay those areas after you've been ordered, then a criminal charge can be laid against you for a breach of that order. The criminal charge can land you up in prison for a period of, can land you a fine or imprisonment, not exceeding a period of 3 years for the failure to pay maintenance. But now this is also in line with what you would be affording. So it's always important that if the financial circumstances of a parent changes, that the court is approached if there is an order for a variation of that order. it's extremely important, because what that does is it takes away the court's ability to incarcerate you for the failure to pay maintenance, because you would be going back to the court to say, I used to earn 35,000 rand. I am now earning 15,000 rand. I need the court to relook my expenses so that a maintenance order is made proportionately to what I'm earning. I can no longer afford a 5,000 rand contribution towards the children because my salary is significantly lower. I'll therefore request the court to reduce my maintenance contribution so that I don't find myself on the wrong side of the law. And that is very important. And I'm seeing a lot of people not doing that. And it poses a problem, because the court comes back to say, but why didn't you come back to tell us that you're not earning enough anymore? So it's extremely important that fathers and unmarried fathers specifically know their ability to vary any court order that is put out against them by any court of law. Now, so we've dealt with the variation of a court order. We've dealt with the application of the maintenance order. Maybe let's look at I'm just trying to put this correctly. Just a second, sorry about that. I'm not sure. Might there be any questions so far that I can take? And then I can just try and wrap up the whole issue of maintenance and what could be what could be known, or what should be known by men now with regards to maintenance.
Well, here's one. Thanks, Robin. That came directly from on the chat from Vic. It says, as the child gets older, can they receive the maintenance directly?
Right. Now, hence the Children's Act is making provision now for the age appropriateness of the child. So remember, maintenance, whether the child receives it directly or not, the court is more interested in whether the child's interests have been served. That's what the court wants to know. Hence, I've started taking the approach of whether, where we are reducing the amount of money that is being received by the mother directly, in an attempt to try and reduce the ability to weaponize the maintenance application system and the maintenance court as against fathers. So it is not always imperative for the mother to receive the money physically. It is whether the needs of the child have been met in that specific month. So has the child received the groceries? Whether the child has received the money themselves, or the groceries have been bought and delivered, or whether the mother has received the money. But the court is more interested in whether has the child's needs been met. So definitely looking at age appropriateness, the child now has a bank account. I can pay the child's transport money or pocket money directly to the child. I don't need to pay it into the mother's account because I've opened a bank account for the child. The court will have no issues with regards to that. In fact, the court is not interested whether that is the case, and the modest that we opt to use in order to make ourselves feel at ease with regards to the payments of maintenance. The court merely wants to know, are the interests of the child served? And that's where the court will leave. I'm not sure if I've answered it adequately. But
interesting. Yeah. Yes. Yeah. No, you did say age plays a role.
It does.
And you touched quite a bit on needs and wants.
Yes.
And I would imagine, if in a case where you were married, can certain needs then be classified as wants? You know what I mean? There were certain times when, if you're married, for example, your costs are probably less than when you divorced. because a lot of duplicate costs. So now, what was a need? DSTV was a need. It quickly becomes a want, I assume, as an example of one if you're divorced. Is that how this is viewed, or is there a big debate on needs and wants generally?
Correct. So I saw a comment now, and it's very true that there are very complicated cases these days. It's extremely true. And the reason why these cases become so complicated and everything becomes case specific is because people's lifestyles aren't the same. For example, if you were married and you used to provide such a lifestyle to your children, and now you cease to do that post your divorce, it raises an eyebrow as to why the children's lifestyle needs to change post your divorce. You'll then have to come forward to the court and say, look, my assets have deteriorated this much, and this is what this is what my income is, and therefore this is why it is appropriate that I'm only giving this much. However, it really is case specific. There are a lot of things that are requested by applicants who are normally the mothers, requesting things in maintenance that shouldn't be requested. However, the contribution is always expected from the respondent in maintenance applications. The contribution should be in line with what the respondent, who would be the father at the time, is able to afford. Your affordability speaks to the maintenance. It really speaks to what you are able to give, what you should give, and what you should not give, based on your inability as well. So the court looks at your affordability for that specific reason, to look whether, if you are paying, for example, the example that I made, if you are paying a medical aid in the amount of 5,000 Rand, but if you stopped paying that maintenance, you would have a cash contribution of 3,000 Rand towards the groceries of the children, which the children don't have. Then the court would say, cancel your medical aid, let the children eat because there is government healthcare available. So the court would look at the alternatives that are available to make each and every case more, let me say, just to enable the father to be able to provide more. So they will guide in that light. So then the medical aid will no longer become a need now, it will become a want, based on the healthcare that is available. So those are the approaches that I know the court will sometimes take into looking at whether certain things on the application for maintenance are needs or wants. Entertainment, it makes no sense for a parent to be paying 1,000 Rand Wi-Fi, but is defaulting on the transportation of the child to get to school. Therefore, cancel the Wi-Fi and take the 1,000 Rand and pay for the transportation is what guidance you would get in the inquiry with the maintenance officer. I would suggest that everybody who goes through a maintenance application have an attorney, whether from legal aid, whether a private attorney. We all have the right to legal representation, whether we can afford it or not. And it's very important that you do get that legal representation, especially in maintenance matters, because what that does is it broadens your knowledge with regards to what you can and cannot do. And you don't find yourself undergoing a process where you don't know what the repercussions of that process might be at the end. So it's always good to have that specific guidance based on your own facts. It will enlighten a lot. It will bring you closer to finding solutions. It also opens way for settlements, because maintenance issues can be settled. I've settled a matter with a mere 500 Rand. But that's because there was ineffective communication between the parties. And if the parties communicated better, there would be settlement and therefore no need for the court's intervention. But these processes are in place for the respondents and applicants in maintenance matters. And it's only important for people to know what is reasonable And reasonable in the sense of different cases is different things. Reasonable could be 20,000 rands for you, but 500 rands for me. So those are the reasons why we need legal representations in these matters.
Yes, yes. The court becomes a voice of logic.
I think that was more the other way around, Derek. I think that was more the other way around. You said 20,000 for you and 500 for him.
Okay. I think Valeria had a question there. Go ahead.
Yes. So I just wanted to speak about I was speaking on the breach of these maintenance orders and the repercussions of those breaches. And I think I mentioned that one of the breaches could be a fine or imprisonment. It could also be that, for example, now the father is now unemployed, has a provident fund, but has no monthly income. Now the court could attach assets and secure maintenance for the future of the child. So up until the child is 18, the court can attach your pension fund and withdraw your pension fund from the pension fund administrator in order to secure the future maintenance of a child. They can withdraw your provident fund in order to secure the future maintenance of a child. Also, in the case where you are in breach and you are currently owing maintenance, the court can attach your assets, sell them through a sheriff's auction or a private treaty auction, and use the proceeds of that auction in order to secure the future maintenance of a child. So those are basically the repercussions. So it basically becomes a civil claim against you for the maintenance portion of the child or children. And it's very important that, hence it is very important that the variation applications be done timeously so that a maintenance order is substituted or varied in order to align with the abilities of the father. So that if the court is kept up to date with what is happening in your financial life and in line with those orders, then it makes it easier and for the court to be able to make determinations as to what is reasonable. So you then, if you are not in breach or you're not owing on your maintenance, then the court has no grounds as to why they should be attaching any of your assets. Because you would have been upfront and open with the court with regards to your affordability. So hence I'm saying it's very important that the court knows as and when your financial circumstances change, what the circumstances are, so that they can make the appropriate orders in line with, so that your pension and provident funds are preserved, so that you are able to have a proper retirement. Also, so that your assets are preserved, so that you don't lose your assets in lieu of maintenance. I mean, nobody buys things in order to lose them through the support of their children. You want to support your children, but you don't want to sell your car in order to be able to support your children. You need the car to go and try to work, to go and support your children. So those are the things that the court looks at when coming to maintenance, and the repercussions and penalties put in place are only effective if you look at them objectively. They are only effective only if there is no adequate communication between the person who has an order against them and the court. If your income depletes by 5 rand, notify the court, because it might have an impact on what you should be paying as maintenance, and therefore preserving all your other assets. It's always good to live realistically, so it makes sense for the court to be updated time and time again as to any changes in your financial circumstances, in order to prevent those consequences that could emanate from the failure to pay maintenance. All right. So that's the only way that we can prevent maintenance from being weaponized against the respondents. Okay, so I think that would be all from my side. I'm not sure if there could be anything else that maybe you want me to deal with.
Jeez, Robin, thank you. Look, this is probably today's discussion is probably not the topic of choice, because much like, you know, someone coming to you and say, have you done your will? Have you prepped for the big day? You're like, no, I'll do it when I'm on leave. You know, I'll always do it when I'm on leave. And this is perhaps one of those topics where, you know, the world is real and real life circumstances happen. So we deal with them realistically as we're doing here. And it's good to see now I've got a few more questions. This is really great. We'll do that. I just wanted to check with you in terms of time, guys. 11 o'clock is our official cutoff time, so we won't go too much longer than that. But I'll allow Avela to ask a question. Then we'll get Tebogo, and then back to Baledi. But before those questions are asked, I like one maybe of advice generally is to say, some of the audience here is quite young, so they're probably preparing for marriages and things like that. What would be your advice around planning your future? Anti-nuptial, COP, or would it be don't think about it all?
Pick right. Pick right. Pick the right person.
Just as a legal person, I know it's celebratory and festive and all of the relatives are there and everyone is having fun. But what is the best way to be future fit when getting into these things?
I like the term future fit. In all honesty, before any marriage, it's better for people to go for marriage counseling. It always, especially legal marriage counseling, because what that does is it opens the doors of knowledge with regard to the different regimes and the consequences that emanate from those regimes. The difference between in community of property, out of community of property, and out of community of property with accrual might serve as an indicator as to what should be the appropriate regime. Yeah. So the appropriate regime is always also case specific. There's a reason why people get married outright out of community of property. And there's a reason why people get married in community of property. And some people normally choose to get married out of community of property, but share everything that they've accumulated from the inception of the marriage. So marriage counseling always gives a clear view as to what the best marriage regime would be. I would suggest legal marriage counseling so that you know what the regime constitutes. Also, remembering that marriage, customary marriages have the consequence of a marriage in community of property. So that's why legal marriage counseling is very good, because it basically draws the line and helps the parties know what they're getting into. It's a contract, and each party to the contract needs to know what they're getting into.
Pick right.
Absolutely. Tebogo, you had a question?
Good day, gents. My question is, I heard Robin speaking about a whole lot of information, and I'm thinking, where can we get all this information besides having to be here? Because there are other men who are not part of Men of Value or who cannot have access to this moment. Where can we get all this information so that we might know what exactly is our rights, what's our responsibilities, and how to go about many other things that we face legally? So.
Thank you so much for that question. Might there be another question that I can take?
Well, Nonhlanhla has quite a few, so Nonhlanhla, I'm hoping that you will. I know you had your hand up. That you'll ask a question. So please do ask a question after. Or would you like to ask now, Nonhlanhla?
No, I'll type it, or I'll ask a bit.
Okay. It's a very involved question. I mean, I can see that you're saying they're quite involved. So, but I think it'd be great to get your input as well. Yes, Robin. Go ahead.
Okay. Also, so we'll go with the question for Abu Tebo, correct?
Yes.
Yeah. So, you know, I say this to a lot of my clients, and they don't believe me. I think attorneys don't know the law; they know where to find the law. That's that's what we were taught. We were taught where to find this information. So, in all honesty, the Department of Justice does have an outline of all these things on their website. So they will have communique on the different courts that they have, the Department of Justice and Constitutional Development. So if you go onto the DOJ website, and you go onto the children's court portion of that website, it will give you all the application forms that you require for every single court in respect of every single matter. It'll give you an overview of what the process in that court is. And it will also show you, obviously don't give you the experience based on these error decisions and previous cases as to what has been done in previous matters. Those you will find in case law. But I think what would be effective is, for the purposes of this discussion, the Department of Justice's website gives information. It also gives the details of the different courthouses so that you know who to call. The clerks are normally of great assistance to the public when coming to such applications and the information required. However, it is always very important to seek counsel if you have any issues. But for the purposes of getting the information, I think the Department of Justice is doing quite a great job on their website, and it will help you a great deal if you go on there, just browse around, see, because they have extended links as well that can lead you to other websites where you can get all this information.
Excellent, excellent. No, thanks for that. I'm just trying to see if there are any more questions, because time is not quite on our side, but I think you've really dealt with quite a lot.
Someone having a burning question. I'm not sure. I'm just looking. Someone had a burning question.
I do as well. I'm trying to find Nontlata's question there, but what was very interesting is she mentioned that things are not as black and white as they seem, and I think some of it was really, even for me, I was thinking, well, is it fair? And everything I've heard here seems to speak to fairness. You know what I mean? It's you know, I work partly in the EE committee in my day job, and in there's something called fair discrimination. So what is the word fair? And does it exist? But I definitely got the feeling from today's discussion that the processes, whether we like them or don't like them, seem to have a good amount of fairness in them. They seem to.
I tend to think so too. You know, it's also important for people to know that the more rational you are, the better the outcome possibly is, because you would have thought about not only your side of the story, but you put everything into perspective, and it brings about better results, in all honesty. So rationality is key, especially for a man of value. A man of value needs to be able to think rationally, put themselves in the other person's position, and I think then you would know how to act as a man of value. I encourage all fathers to do their best to be involved. I encourage all men of value to do their best to be involved, no matter how difficult it is. You know, even we as attorneys face these life trials and tribulations, and then it's only the experience that we've had from other people's cases that will guide us. As they say, Doctor Ikalaf. you know, so I'll also go and find counsel somewhere else if I have such an issue, just so that I'm more rational and have more information from a third party's perspective. So it's always good for people to look into things that way. Yeah.
Great, great. Robin, thanks so much. I'll have Vic give a few of the parting shots, but we've got Letsecho's hand up, we've got Christina's hands up. So if you could indulge us with 2 quick questions. From my side, guys, I'm going to say take care. I really have found this very valuable experience. And I'm so glad that you've joined us, because with Men of Value, we deal with real issues and we tackle them head on. And this is but one that will assist us in creating an environment where men are of value. Letsecho, then Christina, and Vic will then close off. Thank you, Mr. Malinga.
So it's a pleasure.
Mr. Malinga, a very enlightening session. So a question from my side is for the legal representatives. So for instance, for yourself representing a complainant and one legal representative representing the other party. I mean, how fair are you, both sides, in actually looking at the child instead of representing the individuals? Because remember, you know, you do find some men that actually, you know, they're not necessarily thinking of the kid, but they're thinking of themselves and how to preserve and not necessarily give. Then you've got, you understand what I'm saying? So how fair are the legal representatives themselves in actually looking at the child instead of representing their parties? Because their parties are the ones paying them. You know, so I'm paying you, and then, you know, the father is paying the other representative, you know, and we, the father and myself, are fighting. So where's the child in all this?
Correct. That's a wonderful question. Thank you so much for that. I think I'll go ahead and answer that now. So what our ethics, codes, and practices require from us as attorneys is to look into each case specifically in line with what the law requires. So my aim as a family law practitioner is not to get my client out of paying maintenance. My aim as a family law practitioner is to advise my client in line with what is reasonable and reasonably required of my client when paying maintenance. So mine is to advocate for justice.
Oh, you're muted.
Sorry, I missed.
Not afford that 20,000. Factually so. Looking at the needs and wants of the child, it is my duty as the legal practitioner to ensure that my client pays a portion which they can afford. So the interests of the child in terms of our ethics and codes are of paramount importance. That is, in a family law matter, my client is actually the child.
Okay.
And I tell this to so many of my clients. My client is actually the child, but I have a vested interest in what you have to say because I need to make sure that justice is served. So it is a requirement for us ethically to make sure that our clients receive the justice. But remember, we are only mandated and instructed. I am a creature of instruction as a practitioner, and mine is to ensure that justice is served. But I cannot do that if my client now can afford a portion of 10,000 rands, but only wants to pay 1,000. Then I must advise against that. And if my client does not want to take that advice, then mine is to withdraw as the attorney.
Oh, you're muted again.
I'm not sure if I've answered that adequately. Thank you, Mr. Letsecho.
No, thanks.
Yes, you have.
Sorry.
Yeah, I took a deep breath when she was asking her question. I was like,
why do you ask?
No, I did not take a deep breath.
I'm saying I took a deep breath.
Oh, is it? Oh, okay. No, don't worry, my love. You are a fantastic father.
Don't leave me. So,
Christina.
Christina? Christina?
Christina, you're on mute.
Maybe you're on mute if you're speaking. No, she doesn't speak.
Okay, Christina, I think we've lost Christina. Maybe she can write a, Christina? Maybe she can write a question down. Yeah, Vic, anything on the way of closing?
Yeah, look, thanks everybody. Thanks to you, Derek, as the host. Brilliant as usual. Thanks, Robin, Tato. Woo, this was a lot of thinking for men to do. And thank you for showing both sides, right? I mean, I think the whole idea here is, as men of value, we have responsibilities that we must take care of, but we also have rights. And thank you for giving us that dimension. And I hope everybody is more legal wise now in terms of understanding these things, because I think for most people here, that was probably the first time they've heard these kind of commentaries. Normally you start bumping into this when it starts appearing, and even for knowledge, you should have this. So thank you very much. Thank you everybody for showing up on a Saturday a morning. We might need to do part 2 of this, and the saga continues.
For sure. I'm more than happy you can give out my details so that anybody who has any questions is able to email me, send me a WhatsApp. I am available. My office is in Kempton Park, but I do virtual consultations as well. So I'm more than happy to assist any person who would like to get counsel on any aspect of what we discussed today. I think my office is more than capable of assisting.
No, absolutely. Guys, everybody, please, if you go into LinkedIn, please connect with Robin. He's there in LinkedIn, Robin Malinga, and his details. So that's starting point. If you need any information, we're able to give it to you. So with that, go out there and be men of value. And women, thank you very much for joining us. We've got some exciting things coming with 16 days of activism coming up. We're going to join Men of Value and Women of Valor, the old Celebrating Women event, and have some real conversations around how we can dynamically, as a society, work towards improving our engagement with each other. So until then, thank you very much, and good afternoon. Or is it still good morning? Good morning, and enjoy the rest of the day.
Thank you, everybody.
Cheers,
have a good day further.
Thank you. Bye.
Bye.
Thank you for watching this ValueEd on the go recorded live session. If you enjoyed this session and would like to learn more, please head through to valueed.co.za/members. By becoming a member, you will be able to join our live and interactive sessions. This will allow you to ask the host questions, but also meet our other ValueEd family members who are part of this course. You'll get access to all of our on-the-go recorded live sessions, as well as our other ValueEd sessions, including the Mogul Masterclass, Leadership Masterclass, and Career Discussion Academy. So, we hope that you decide to join the ValueEd family by heading through to valueed.co.za/members. Until then, we hope that you stay inspired to make better choices for tomorrow.